welcome back to Court TV Live. I'm Julie Grant, in tonight for Vinnie Politan. Boy, oh boy, are we turning to an interesting legal story out of Kansas City, Missouri, where, brace yourselves, folks, a woman has been awarded a $5.2 million insurance settlement against GEICO. The woman claims she contracted a sexually transmitted disease while having sex in her then-boyfriend's car, which was insured by GEICO. The woman, identified as M.O., had notified GEICO that she was planning on seeking a $1 million settlement from the man and argued that the man's auto insurance provided coverage for her injuries and her losses. However, GEICO rejected her settlement offer, saying the woman's claim did not occur because of normal use of the vehicle. Well, an arbitrator then weighed in and determined the woman should be awarded $5.2 million for damages and injuries, a decision that was then upheld on Tuesday by the Missouri Court of Appeals. And now GEICO has filed a federal lawsuit arguing the woman's claims are not covered by the man's insurance policy. So we posted this story to our social media pages at Court TV, and we asked you, our 13th juror, should GEICO have to pay her? We begin with our comment of the day from Rachel, who says, quote, absolutely not. But the man should be held accountable for not disclosing his positive diagnosis. Thank you, Rachel. Okay, let me bring in the think tank right now, see what they think about this one. I can't even believe I'm asking you all about this. Eklund, help me out and go first, please. Should GEICO have to pay up here?
How? How did we get here? Like, how did they negate any other way for her getting HPV, like the one that you can get off of toilet seats? Like, how did they negate every other place she could possibly get this, like, STD? She could have gotten it from a bench, from the gym. They negated all of that and really said it was from this car. I want to know how. Like, I am shocked. I want to know how. Like, it makes no sense. Like, how? How did that happen?
One of our viewers said the same thing. Yeah, on Twitter, fstop414 said, quote, what if the woman had sex at his home? Is his homeowner insurance liable too? Or maybe at the office, would the company be liable? Pure insanity, and I can't believe the court ruled in her favor. Brian Watkins, what do you think about what fstop had to say there?
I agree with them, but this is an internet story, and there's a lot of half-truths on the internet. And if you look deeper into that case, GEICO wasn't sued, the man was sued, and he didn't respond to the lawsuit, and she got a judgment of $5.2 million. The fact that the individual filed a claim with the insurance company didn't pay, now they're trying to basically what we call open the policy, which means GEICO would have to pay the entire judgment for what he did. They're not claiming that GEICO did anything wrong or the car did anything wrong. So the story comes out a little twisted. However, I do think this is going to get overturned on appeal. The judgment will not stand. Like I said, they didn't even allege that GEICO did or the car did anything wrong. The lawsuit was against the guy. The question is does GEICO have to pay for the guy's wrongdoing because he was insured by GEICO? That's really the question. So when you look at it like that, it's a little less sexy, or maybe that's a bad term, but
you're really on with the puns tonight, aren't you, Brian? I know, one after another. He'll be here all night, folks. Oh my gosh. Well, and to your point you just made, Brian, we got a comment from Raymond. This is a good one. Raymond says GEICO should sue her for a frivolous lawsuit. Ian Freeman, what do you think?
I can see why people are outraged by this, right? People hear this and they automatically go back to which one? The McDonald's coffee case, right? We're all thinking about that from 20 some odd years ago. This doesn't happen all the time. So this shouldn't be an example of frivolous suits being out there all the time. The insurance companies give it back every single day. Obviously, you can tell I'm no fan. Now, let me just be clear. The language here in the policy is what is allowing for this. The language says that if someone is harmed while operating or in the vehicle, so it's pretty vague policy. Now, I'll tell you what happened. Right after this happened and this judgment came, you better believe it, that every chief legal counsel for every insurance company got a notice on this one. They're changing the language in their policy at every moment of this. She sued, just as Brian said, Policy allows for it. We'll see what the courts do.
Yeah. And Ian, speaking of great minds thinking alike, you mentioned the McDonald's coffee cup case. Samantha, look at her comment here. She says, this is worse than the McDonald's cup spilling hot coffee on the person. This is a complete joke. There's no way this can hold up. And if it does, then GEICO and other insurance companies will have to be pulled into a lot of criminal crimes for what happened in those vehicles, which makes no sense. I love it. Karina tonight writes, quote, GEICO is not responsible for her choices. Karina, thank you for that. And Christina wrote on Twitter, opens a can of worms for insurance companies for sure. Thank you all. Great comments tonight. Think Tank, you all are the best. Thank you so much. Eklund, Mercy, Brian Watkins, and Ian Friedman for coming and closing arguments tonight. Have a great weekend.